Hey, Rob and Kevin. With the new law allowing 15-year-olds to get their license, parents are wanting to know what their liability is for their teenage driver.
Welcome, everybody, to the Legal Notepad podcast. And Lauren, you are right. With the governor having signed that bill and now 15-year-olds can get their permits, our social media is blowing up, and parents do want to know, what is my liability for any of my teenager drivers, whether they're 15, 16, 17, all the way up to they're an adult? What is my liability? Well, we're going to answer that question today. Let me first tell you who's in the studio. Obviously, you just heard from Lauren. Lauren, thanks for being here. We also have Kevin Burke, our resident appellate lawyer, who always goes through the case law with us and answers those questions. And you're also going to hear from our very special guest, Adam Redden, an attorney in my law office who has researched these cases, read the cases, and will be prepared to go through them. Let me do this special kind of way we're going to handle the podcast today. We have a lot of non-lawyers tuning in. They've seen the commercial, etc. So we're going to spend the first part of the podcast going through and answering the questions specifically for lawyers and non-lawyers. And then the second half of the podcast, we're going to get very detailed into the case law for all the lawyers to learn exactly how this law has developed. Let me remind everybody, this does qualify for continuing legal education credit. And at the end of the podcast, you'll have my email. Shoot me an email and I'll give you that activity code. With that said, let's jump right in and answer this question. So to answer the question, what are the parents' liability for your minors' children driving an automobile? We have a statute in Kentucky. It is Kentucky Revised Statute 186-590. And it's been around for many, many, many decades. And it does set forth the answer to that question. So let me give all the non-lawyers a real general description. And here's how it works. If your child is driving a car and they cause a wreck, you can be held responsible as the parents under two broad scenarios, okay? Broad scenario number one is you take them to get their permit or their license. You're the one that signs the application, okay? You are on the hook. You're responsible for anything that they do in that car because you signed the application. When you sign the application, you are saying, I will be responsible for that child up until their age of 18. Okay, that's number one. But number one has an exception. Just because you sign the license doesn't mean you're responsible if you make sure the vehicle that they are driving has insurance. So mom takes her son down, mom signs the application. They pass the test, thank God, because gosh, that's the world to them. They pass, and you let them drive a vehicle, and it has insurance. Then the simple fact that you signed the application doesn't mean you're at fault. That you're also lied because you made sure they had insurance. So parents always make sure they have insurance. But there's a second category, and that category is much broader. Forget who signed the license. Forget if they have insurance. Set all of that aside. This statute, 186-590, also says that you are liable if you furnish a vehicle to someone. If you're the owner of a vehicle or you furnish a vehicle to a minor, by allowing them to drive that vehicle, you become responsible. And that's not always the same person that took them down to sign their license. So you need to make that decision when you allow either your child or, heaven forbid, another person under the age of 18 drive your vehicle if you feel comfortable assuming that responsibility, because those are the two things. Kevin, tell me, did I summarize that okay? Do you think the general public understands now what those are?
No, I think you did a great job, Rob. And what people, parents who are listening to this, and it's not just, as Rob mentioned, it's not just parents. It's anybody who might allow a minor to drive their vehicle. That also applies here. So that could be grandparents, that could be aunts and uncles, relatives, friends of the family, that sort of thing. So you need to be aware that anytime you allow a minor, somebody under the age of 18, to drive your vehicle, you have responsibility under the statute. And, of course, there's the saying, with great power comes great responsibility.
Spider-Man.
Right. Many things, including Spider-Man. So with great power comes a great responsibility. Of course, with great power to the minor comes great responsibility to the parent here, and to anybody who also loans a vehicle to a minor. But Rob, you've summarized it great. I don't think I need to add anything to what you've said. It is the statute, other than to highlight this. The purpose of the statute is to make sure that if a victim of injury on the roadway, somebody who's hit by a minor, that there's some source of recovery here, and that recovery is also not just the child, not just the insurance, but also the parent as well under this third section of the statute you talked about, which is really broad when you think about it and the practical implications from that.
Yeah, so I mean, they want to make sure that if a minor, anyone under the age of 18, causes an accident, that there's a recovery for the victim.
Correct.
So you've got to make those decisions when you're either signing for your kid's license or you're letting another minor use your vehicle.
That's right.
I tell you what I'd really like to do, and first of all, most people listen to this audio. Most people are on the Facebook, the Apple Podcast, Spotify. We're on all those platforms. A lot of people watch on our YouTube channel. If you're watching on our YouTube channel, or if you're not and you want to go to our YouTube channel, we'll have all these on the screen, so you'll be able to actually see it, see the statute, read it for yourself. So that's another way to take in this information if you want. So let's do this. Again, we are kind of starting the podcast for the non-lawyer with some examples, again, for all those interested, and I hope everyone sticks around. We're going to talk about some case law in Kentucky pretty soon. But before we move off that part, what I'd like to do is give some examples. And what we're going to do is we'll have Lauren give an example, and then Adam, you're new. How about you answer the questions?
Perfect.
How about that?
Happy to do it.
So Lauren, take it away. Give us our first example.
Sure. All right. So mom takes 16-year-old to get his license. Mom signs to get his license. She does not get insurance on the vehicle. Are they liable?
I would say yes. Under Part 1 of this statute, it's incumbent upon the parent to have insurance on the vehicle, or insurance covering their child's actions. That's one of the purposes behind this statute, is to encourage financial responsibility. There is mandatory insurance in Kentucky, but this also encourages the parent to get additional insurance if they realize that they're on the hook for any actions of the minor. So under the statute, though, under that scenario, yes, the mother would be responsible for the actions of their minor child.
Well, but let me throw a loop at it, Adam. So mom signs the license, doesn't have insurance on the car. But, the reason she didn't is just because the wreck happens a day or two later. She means to call State Farm, just hasn't done it yet. It was just a mistake. Is she still liable?
I think she is. Under the clear reading of the statute, she would be on the hook.
Well, so what if mom gets insurance and the kid is insured and they have insurance for 6 months, and then mom's late on a premium or forgets to pay the premium and the policy lapses? Is she responsible then?
Again, the courts look at the clear language of the statute, and the statute requires her to have insurance in effect if she signed for the license. And since she did not have insurance in effect, she's on the hook.
Kevin, did Adam get the question right?
100%. Great job, Adam. Yeah, that's absolutely right. I mean, so the folks who are listening are kind of getting the picture that most of the time the parent is going to be responsible here. There are maybe some exceptions, but you need to I think if you're a parent, you need to assume you're going to be responsible at the end of the day under this statute. But that's I would say maybe more of a unique circumstance where the parent signs for the license, but then the child is in a vehicle that is uninsured. But it happens, right? It happens for any number of reasons. Like you said, it could be, well, maybe one of the parents, maybe there's a miscommunication between parents, right? Whether the premium was paid or whether the car was going to be insured, or maybe maybe the policy lapsed. But under the statute, there's no exception. The parent's responsible under those circumstances.
And really, there's a practical point. I mean, I understand life gets busy, and you know, and my wife, we have 2 kids, and we're always running around. But there's certain bills you might make a little late. You accidentally pay your LG&E bill late or your water bill late, and there's no real repercussions. I'm talking a couple of days. But on your auto insurance, you've really got to make sure you're paying that timely, and that's true whether you have a minor or not. But if you have a minor, you really need to make sure you're keeping that up.
Absolutely.
Okay, good. Well, that's an example. We want to cover a couple more. Lauren, you got another example for us to
Sure.
answer?
All right. So mom takes child to get licensed. She signs off on the license. She gets insurance on the car. But dad, who has a completely different car, lets child drive his truck. Dad, tells the child, hey, you can drive my car. Who is liable?
Man, that's a great example. Adam, what's the answer?
Sure. So mom is off the hook. Mom, even though she signed for the license, she has insurance in place. Dad, on the other hand, there's part 3 of this statute that says if you furnish a vehicle or allow a minor to operate your vehicle, or even if it's not your vehicle, if you were borrowing someone else's vehicle and you let the minor use that, you're on the hook. So under this scenario, dad would be on the hook for the minor's negligence. Mom would not.
Yeah, and that's an interesting example because so mom signed, she had insurance on a car, and that was good. So she was covered as long as she didn't also furnish the vehicle. Now, remember in this example, we said mom's not the one that gave the kid the car. It was dad that did. Dad gave the kid the car. So assuming mom really isn't the one that furnished it, it was really dad. Mom's off the hook and dad's on the hook. Now, it's probably family assets. It's probably family things that you want to protect, but it would be dad, not mom.
Correct.
Kevin,
No, technically that's right. I mean, most of the time it's going to come from the same pool of money or that sort of thing, but not always. And so sometimes those distinctions can make a difference. But that's how it would legally play out. Correct.
And it can be a situation. Mom and dad are divorced.
Mm-hmm.
So mom gets insurance and gets the license, signs it, gets insurance. But truly, dad living in a different household is the one that furnishes the vehicle to the kid, and that's a little cleaner situation.
Right.
But it's remember, if you sign and get insurance, sign it and you don't get insurance, you're responsible. Sign it and you get insurance, you're not. But also broader, anyone that furnishes. So.
That's right.
Yeah, okay. You got another example? Again,
Sure,
I'm
got a
hoping the
couple more.
non-lawyers here are still tuning in. We want to give these examples before we jump into the case law because I think that's kind of the practical technique.
All right. So I let a minor who I am not related to, and I did not sign their license application, borrow my car. Am I liable?
Well, first of all, Lauren, you work for a law firm, so why would you do that?
Well, I do have a stepson that will be 15 in January, so maybe. I don't know.
This one might actually apply.
It might.
All right. So what were the facts? Tell it one more time for the listeners.
Yep. So I let a minor I'm not related to, I did not sign their license application, borrow my car.
Kevin, let Kevin go on this one. Go ahead, Kevin.
So this is a Section 3 example. This is under the statute. Section 3 says that anybody who causes or knowingly permits a minor under the age of 18 to drive a vehicle, or any person who gives or furnishes a motor vehicle, is also responsible along with the minor. So in that circumstance, you're gonna be responsible under the.
You let a minor borrow your car.
Yeah.
Even though you didn't sign the license, you had nothing. You're on the hook. You're saying, I'll take on that responsibility.
That's right.
And that does happen sometimes. Adam, you agree?
I agree.
Kevin's not wrong?
He is not wrong. 100% correct.
I've never been in a situation where Kevin was wrong.
You need to talk to my wife.
And there at home, you're just responsible.
I'm responsible.
I side with the
I'm
wife.
responsible for everything, in fact.
It's Kevin's fault. I think we have 2 more examples. Let's bust through these last two examples.
Let's see. We may have already touched on this one. But this example, let's say mom takes kid to get licensed. The kid gets his license. Mom does get insurance on the car, but unfortunately, dad lets the insurance lapse. So who would be liable?
Yeah, I kind of jumped in on accident and covered that earlier. But Adam, real quickly, what's the answer?
Well, mom would be on the hook, as we talked about before. And potentially dad's on the hook now, too, because if dad has control of the vehicle or allows the child to operate the vehicle, then under Part 3 of the statute, he would be responsible.
Okay. And then I think I was just kind of looking through the Facebook page here, the legal notepad for those that are following it. And was there one more? It
Yep,
looks
got
like.
one more, looks
Yeah,
like.
yeah.
Let's see. Let's say I borrow Kevin's car with Kevin's permission. I then let 17-year-old drive Kevin's car. Can I be responsible even though I didn't own the car?
Kevin, it's your car. You tell me the answer.
Oh my gosh. It's my car. They took yeah. Yeah, the answer is yes. That in this circumstance there was this is a section 3 under the statute. This is a section 3 scenario. Causes or knowingly permits a minor under the age of 18 to drive the vehicle. Any person who gives or furnishes a motor vehicle under either or both of those, there's going to be responsibility here. So, yeah,
Pretty clear cut.
pretty clear cut.
And I think under that scenario too, Kevin would be on the hook because you were the permissive user who gives it to another permissive user that follows the chain back to the owner. So not only would you be at fault, Lauren, but Kevin would hold responsibility too.
All of the above. Everybody's a defendant.
Yeah, and you got to be careful. It's always broad. If you let someone borrow your car and then they let someone borrow it,
Right.
even if they don't tell you that they're going to, you're likely on the hook. There's some rare exceptions when you said you can borrow it, but Kevin can't borrow it.
Right.
And then if they give it to Kevin, it's a closer call, but
Right.
you'd rather not find yourself in that.
You don't want to be there. You don't want to be in that situation.
Don't want to be in that situation. Okay, great. Well, I think we've covered kind of the examples that we wanted to give without getting into the specific case law. So again, a lot for the non-lawyer listeners. Before we move on to the case law, I think we had talked about a couple of practical pointers. So for all that tuned in because you saw it on TV and you wanted to come up here and figure out the answer, practical pointers. What can I do to protect myself? Well, I mean, if you're a parent and you're going to sign the license, then you definitely want to try to keep insurance. That's number one. And, you need to decide based on your financial situation and the assets that you want to protect, how much insurance you should buy.
Right.
And Kevin, I think you and I talk about this all the time. I mean, insurance can be expensive, but if you're trying to protect your assets, your home, your various accounts, et cetera, it's good to purchase as much insurance as you can.
Right.
Because that insurance covers you. If you are, it's called imputed liability. If you have imputed liability for the injuries that your son or daughter or any minor causes, you want to have that coverage there.
That's right.
The other one that we kind of ballparked back and forth in preparation for this was, what if you sign your son's or daughter's application and you keep insurance? What if the car's in their name? So you're not
Right.
really furnishing it. Kevin, give it your thoughts on that.
Yeah, I think this is one of those situations where it's just going to be it's going to depend on the specific facts and circumstances of what happens. But I think there's a chance that if the minor owns the vehicle, it's titled in their name, there's insurance covering the vehicle, that it's possible that the parents might not have liability under this statute. I wouldn't chance it. I would just assume if you're a parent, you're going to be responsible under some, it's. I don't think you can take it to the bank. Okay, I don't think it's something you can say, oh, definitely, I'm going to make sure my kid buys the car, has it titled in their name. I'll make sure it's insured, all that, and I'm going to be fine. I don't think that's the case. And the reason I think there's some wiggle room here is because under Section 3 of the statute, it says any person who gives or furnishes a motor vehicle. Well, I mean, what's that mean? Did you help the minor pay for the vehicle, even though it's titled in their name?
Did you buy it for them?
Did you outright buy it for them? So there would still be circumstances where you could be held responsible as a parent, even with that protective measure.
So the broader takeaway is, if you want to give, because not everything in the law is black and white. People ask all the time, what's the law saying? I'm like, well, it doesn't always tell you. But I think your best shot, if you were worried about liability, would have the vehicle that your minor child is driving in their name. At least you have an argument. I didn't furnish it to them. It's their vehicle. They're not driving mine. Would it fly? I don't know. But if it's not in their name, and you let them drive it, you're definitely on the hook.
What we're saying is there's a chance.
There's a chance.
We're saying there's a chance, right?
It would be your best case scenario.
Right.
And then, of course, buy all the insurance that you can afford so that you're okay with that.
Right.
Good. All right. Well, that kind of touches on the what's the statute say? What's the general answer? I hope everyone kind of has an understanding of that. I now want to kind of transition into the case law and things like that. All right. So, Kevin, now let's talk a little bit more specific, and Adam, let's talk a little bit more specific about the actual statute, kind of getting in more to the language and the case law and those things. Remember, to the lawyers out there, the goal here is to get you 1 hour of continuing legal education. I think we're 21 minutes in or so we'll kind of keep moving and cover what we can. So the statute is KRS 186-590. If you're on the YouTube channel, that's going to pop up, and you can see it there. It's called Minor's Negligence Imputed to Person Signing Application or Allowing Him or Her to Drive. It's a pretty specific title there, Kevin.
A lot of words.
A lot of words, but I think it does pretty well describe what we got going on. There are essentially 3 little sections. It's not a very long statute. There's 3 little sections to the statute. Again, getting kind of into the nuts and bolts of this now. Section 1 says, any negligence of a minor under the age of 18, so anyone under the age of 18 who's been licensed upon an application signed when driving any motor vehicle upon a highway shall be imputed to the person who signed the application. So there you go. And there's other language, but that's the most important part of that. You sign the application, the negligence is imputed to you. And then it says that person shall be jointly and severally liable with the minor for any damages caused by the negligence. So if your son or your daughter or any other minor that you know, well, in this case, we're talking about someone that you signed the application for, they cause an accident, they hurt someone, that liability is imputed to you. But there's also a Section 2, and Section 2 can relieve you of that. And Section 2 generally says, without reading it, if you keep insurance, right, for that minor on the vehicle, that eliminates your responsibility under Section 1.
There you go.
So it completely eliminates that joint and several liability imputed to you under number 1 if you keep insurance. So that's great.
Mm-hmm.
Then there's a third and final section, and it's really, really broad. Really, really broad. And here's what it says. Every motor vehicle owner who causes or knowingly permits a minor under the age of 18 to drive the vehicle upon a highway. So it starts there. If you own the vehicle and you allow them to drive it, you're responsible. Okay. But the statute goes on to say, and any person who gives or furnishes a motor vehicle to the minor shall be jointly and severally liable. So 2 things there, right, Kevin?
Right.
What are those 2 things?
Well, first of all, you've got the motor vehicle owner, right? So the motor vehicle owner causes or knowingly permits a minor to drive the vehicle. So that's specific. You have the owner and says, hey, 16-year-old, here's the car, you can drive it. And then the next part says any person. So that's not necessarily limited to the owner of the vehicle. That could be someone else who says, oh, yeah, there's a car out here, you can drive it. Then that person who gave permission is also responsible under that second part of that section. Anybody who gives or furnishes a motor vehicle to a minor is also liable.
Yeah, so that's the really broad part. I mean, it doesn't have to be the owner of the car, and we're going to look at some case law on that. So, so generally, that's the statute. That's what it says. There are lots of cases that go around and talk about this particular case, and I thought we'd just jump right into them. Kevin, you want to jump in? Why don't you tell us the first one, Bottoms versus Smith? It's a Court of Appeals case from 2022.
Yeah. So this is, as Rob mentioned, this is a Court of Appeals opinion from 2022. And just kind of bird's eye view of what happened. You've got a grandfather who's watching over his 15-year-old grandson. And the grandson is visiting, and the grandfather is taking a nap, as grandfathers do sometimes.
I love a good nap.
I do too. I'm not even a grandfather. And so he's taking a nap, and when he's napping, the 15-year-old who doesn't have a license, okay, because that wasn't in effect yet in 2022, takes the grandfather's Chevy Silverado out for a joyride.
It's a big truck.
Big truck. And so driving around and takes it, and then unfortunately hits a pedestrian. And so there was a lawsuit brought by the pedestrian against the grandfather in this circumstance, under the statute we're talking about, KRS 186-590. So this is a KRS 186-590 subsection 3 case. There's no argument here. There's no argument here about signing a license or anything like that. Again, it's a 15-year-old under it back then.
15-year-olds couldn't get a license.
Couldn't get a license,
Nothing
so
to
it
sign.
wasn't nothing to sign.
Right.
So it's not a section 1, section 2 issue. It's a pure subsection 3 issue, whether the grandfather can be held liable when the 15-year-old takes his Chevy Silverado out for a joyride and unfortunately hurt somebody in the process.
And under Section 3, it says you can be the owner or anyone else.
Mhm.
He's the owner of the Silverado, is what my takeaway from the case is. The grandfather is.
Correct.
So kid takes the truck while grandpa's taking a little nap. What's the court say? He hurt somebody. Who's responsible?
Yeah, and this came out of Nelson County, and we mentioned that. Shout out to all the Nelson County folks out there. And so so Bardstown and Nelson Circuit Court, on a motion for summary judgment filed by the grandfather, says, grandfather's not responsible here, because the grandfather was doing what? Taking a nap, and he didn't give permission to the 15-year-old to drive his truck. So his argument is, look, I didn't know what was going on, and I shouldn't be held responsible for that. And the Nelson Circuit Court granted his motion for summary judgment on that and said, yeah, there's not permission here. He didn't give permission to the child to do that. Now, there were some other arguments that the plaintiff made, not just the statute, but several other negligence theories, including negligent entrustment, negligent supervision, common law claims, not based on the statute necessarily, but the primary argument was based on Section 3 of the statute, causing or knowingly permitting, giving or furnishing. And the argument was, well, look, yes, okay, he wasn't awake. We agree with that. But this kid was under his watch at the time. And he also knew this kid, had been in trouble before. Maybe not a good idea to nap with this kid around, and you've got a truck and other stuff there. So the argument was, well, look, you effectively or you impliedly permitted him to use the vehicle because you just weren't on the ball. In other words, you weren't paying.
You didn't lock the keys up in a safe. Come on, it's
right.
your fault.
You left your keys out. You were napping. That's how they were. That's how the plaintiff attempted to get to permission or for giving or furnishing, however you want to look at whatever language you want to look in Section 3, to try to get to the grandfather's liability under these circumstances. But that Nelson Circuit Court rejected that argument, and it goes up to the Court of Appeals, and the Court of Appeals, looked at the statutory language, and it underlined the words knowingly permits. Knowingly permits. That was really important for the court, and they keyed on that language.
And that's right out of the statute.
That's right out.
Knowingly permit them.
That's right out of the first part of that Section 3. So they key in on that and said, well, look, knowingly permits. There's no, we understand your argument about implied permission. There was also an argument about the grandfather didn't call in once he knew the vehicle was taken. He didn't call in immediately, which was sort of like maybe showed that he knew that the kid took the vehicle. He didn't call the cops immediately. So there was that kind of argument. But which they said, well, that's a decent argument. They acknowledge that, but they said that doesn't get to knowingly permits. And so the long story short here is they affirm the summary judgment for the grandfather.
Yeah, so and it's probably the right result under this statute. And he's not a Section 1. He didn't get the license. He didn't sign for it. So we're just looking at Section 3. And as Kevin said, the statute says if you're the owner, you have to knowingly permit the minor to drive. Well, Grandpa's sleeping. He never tells the kid he could use the car. He takes it, essentially steals it. Just
we can
bring
call
it
it that.
Yeah,
we could just say that. Yeah,
he's going to bring it back. But he didn't knowingly permit.
Right.
So in that case, grandfather, owner of the car, was not held liable.
That's correct. And once the court navigated through Section 3 of the statute, of course, there were the other theories of liability that the plaintiff asserted, including negligent supervision, training, and all those. But those claims, if they weren't going to have success on the statute, if the grandfather wasn't going to be held liable under Section 3 of the statute, well, the others weren't going to work either. So the court, but in the interest of completeness, the opinion goes through those other claims as well and rejects them. Just to be complete, to tell people, make sure they did. To send a message, they got the argument. They didn't skip over it. They knew what the plaintiff was arguing, and they wanted to be complete in their analysis.
So they went through the negligent entrustment and all those various things.
Correct.
At the end of the day, the broadest one would have been this statute, and they said you didn't knowingly permit.
Right.
And that kind of cuts everything else off at that point in time.
That's right.
All right. Well, great. Well, let's keep moving. We do have a lot of cases that we want to cover. Adam, you are being tagged in. For our listeners, we're going to move on to Commonwealth Fire and Casualty Insurance Company versus Manus. It is a 1977 case from the Court of Appeals of Kentucky. And Adam, tell us a little bit about this, kind of summarize what you want to hit and what should our listeners know.
Sure. So this is another permissive use case, and this one actually has a lot of moving parts in it.
And for the listener, there's a deck action that goes along with this. We're going to skip a lot of the deck action stuff, the declaration action on the insurance policy, but go ahead.
Yeah, this case actually went to trial, and following the trial, there was a deck action. Insurance companies fighting whether it's covered or not. But under the facts of this case, we have a plaintiff who is a minor passenger in the car. The car is being driven by a 16-year-old who didn't own it. What happened was the owner of the vehicle had given permission to her daughter to use it, and then her daughter gave the 16-year-old driver who caused the collision permission. So the first question is the owner on the hook in this case? And that question of permissive use actually went to the jury in this case. So the jury was asked whether or not the owner's daughter had permission to use the vehicle. The jury found yes, which in turn meant the person she gave the vehicle to had permission also. So the court found her on the hook under Section 3. But there's another twist to this case. The 16-year-old driver, his father actually had insurance. It was a Safeco policy. And the question was, when the father was sued, is the father on the hook of the non-owner 16-year-old driver? And the court found that there was, in fact, insurance on the vehicle. The father had provided insurance to the 16-year-old. So the father of the driver, in this particular case, under these facts, was found to not be liable under Section 1 of the statute, because even though he had signed for his son's driver's license, he had provided insurance that covered his son for the operation of that vehicle and was off the hook.
So Dad is the one that actually took son, got him to sign the license, and Dad kept insurance.
Correct.
And Dad had nothing to do with giving permission to someone to use the vehicle, who then gave permission to someone. Dad had nothing to do with that.
Correct. Dad didn't own the vehicle. The vehicle was owned by someone else who actually gave the permission. So Dad did not fall under Section 1 or Section 3.
Well, I love this case because it involves both sections. So you have Section 1 analysis through Dad, right? Dad's not liable because he did everything right.
Right.
And he didn't get permission. And then he didn't, under 3, get permission. Was it Mom, on the other hand, didn't sign the license? Or who was it that gave the car?
So the car was given no relation to dad of the driver. It was an unrelated adult who allowed her daughter to use the car, and her daughter allowed the 16-year-old boy to use it. His name was Ken Downey.
So owner of the car is purely a Section 3. Dad's off the hook under Section 1. Owner of the car, who's not related to the minor, is purely Section 3.
Correct.
And the court said, yeah, Section 3 applies to you.
Yes.
Yeah. It's a great case for that reason. It kind of evaluates, you don't get that multifaceted type of one person signed, a completely unrelated person gave him the vehicle. It's like,
well, I think it gives you a good picture too of how far up the ladder this liability will go. And so this case lays out that if you give your minor child a vehicle to use and then they let another minor use it, you're on the hook not only for your minor child's actions, but whoever else they give it to.
It's one of those things where, practical takeaway pointer for parents here is, if you are providing a car to your child, which a lot of parents do, either help them get or get them for them, I think you should explicitly tell them they're not allowed to let any other minors drive the car. At least create some type of factual question of cutting off that you gave permission so they can get permission to anybody else. Because you can specifically revoke permission. You can specifically say, no other minor other than you can drive this. And that would at least give you an argument if someone tried to hold you responsible. Kevin, I see you nod. Do you think that?
I agree. And, it's, again, very fact specific. The circumstances will dictate the result there. But I think you have your best shot to avoid liability by doing that.
Well, plaintiff would probably come along and go, there's no way you thought to tell them that we shouldn't do that.
Right.
And you would say, well,
I heard this podcast,
right, but I listened to the legal notepad.
We'll get blamed.
Yeah. And Rob and Kevin and Adam said, make sure you tell them. And I did. And here's proof that I listened to it on May 22nd. So
that's right.
Keep track when you're listening to our podcast, get your CLEs, and it might even stop you from being liable.
There you go.
And that's a good summary. Anything else we need to know about that particular case as we move on?
No, briefly hitting on the deck actions. So Safeco came in. That's the insurer of Downey, the 16-year-old, and the father tried to get out of coverage. The court would not let them out. And then the actual injured plaintiff filed an uninsured motorist claim. And the court found that there was, even though the owner of the vehicle did not have insurance, the driver was not uninsured. So there was no uninsured motorist claim.
Got it. So that kind of resolved the deck action side of that.
It did.
In that case. Well, good. All right, well, the next one's pretty easy. Let's just keep on moving through. Kevin, if we can, next, let's talk about State Auto Insurance Company versus Reynolds. It is a Court of Appeals case from February of 2000.
Mm-hmm.
Again, these cases start to get really old because this statute's been around for so incredibly long.
Right.
But this one's just 2000. And I love this one because it's about an emancipated minor. And surely if the minor's emancipated, then there's no possible way the parents are liable. Right, Kevin? I mean,
you would think so, but it's not so.
That's not what the law says.
That's right. So,
in case the non-lawyers are still listening, and I hope that they are, emancipated, you may let them know what that means as well.
Right. So, we'll cover that. Bird's eye view here. State Auto versus Reynolds involves a situation where a minor 17-year-old is involved in a wreck in a I think it's a Pulsar. But anyway, the car doesn't matter. The car is owned by the 17-year-old's father, who is titled in his name. He was a co-signer on the loan for the car, and it was the 17-year-old was allowed to drive the vehicle. So there's no question about permission here. Now, procedurally, it's a little bit unusual. Why is State Auto? We might ask the appellant here. What happened? Why are they why are they involved? Why are they suing the father? Okay, and the answer. So to dig into the weeds of it. After this wreck, which is a fatality, 2 people died, 2 passengers in the 17-year-old's vehicle. One of them one of their estate had underinsured motorist coverage, and the insurance companies paid the underinsured motorist funds, and then they sought to recover from the father. So they're the plaintiff seeking to recover now from the father, arguing that the father is liable under subsection 3 of the statute.
They paid their benefits and they want to go get their money back.
They want to recoup their money. So it's the insurance company who's the plaintiff here, and they're seeking recovery from the father of the 17-year-old. Father of 17-year-old says, look, my daughter moved out, so don't look at me. I can't control her. I mean, she's her own person. She's 17. She's living outside my house, and there was a dust up. Oh, I don't want to get into it, but there's a big dust up here, and I don't have any control over what she does. She's emancipated, and so the circuit court agreed with the father and said, emancipation for all intents and purposes means that you don't have any control, so the statute doesn't apply. The insurance companies then appealed. The insurance companies are the appellant, so they said, look, that's wrong. It doesn't matter whether the statute doesn't say anything about emancipation, right? It talks in terms of owner of the vehicle or one who gives permission. Minor is a 17-year-old a minor? Yes.
If you're emancipated and you're under the age of 18, you're still a minor.
Right.
By definition.
So the Court of Appeals goes through that analysis. They look at the plain language of the statute. They look at 186.590, Section 3. They say, well, what does it say? It says every motor vehicle owner is the owner of the vehicle. Is the father the owner of the motor vehicle? Turns out, yes. Yes, he is. Did he knowingly permit his daughter to drive the vehicle even though she was emancipated? Answer, yes. So the only question is, what do we do? What do we do with this emancipation issue? And the Court of Appeals goes through that analysis, and it says, they quote some older cases, and they say that the doctrine of emancipation is a recognition of the right of a parent to relinquish control and authority over the child. Okay, well, we understand that. That makes sense, but the child still has the same it still is a minor, so the child still has the same relationship with the parent. There is a minor and there is a parent, whether or not the child is also emancipated. So the court goes through that analysis and eventually concludes that it doesn't matter whether the child is emancipated. All that matters is what the statute says, and the statute imposes liability on the father, whether or not she lived in the house or was emancipated.
And I think you said the vehicle was still in father's name.
Correct.
So one of the things that father could have done would have been to not furnish this vehicle. I mean, his daughter moved out.
Right.
But he's still letting her drive a vehicle titled in his name.
Right.
So they could have switched over the title or taken back his vehicle. I mean, there were things, if you find yourself in a situation where a child is to the point that they need to be emancipated, like this child is running wild, I can't control them. I mean, that's usually how it comes back. You need to get the vehicle that they're driving out of your name. You probably need to get the vehicle from them. So there were steps he could have taken.
Right. And I think that, that weighed on the court's mind here is, look, there was still, he was the owner of the vehicle. He didn't take those steps that you mentioned, Rob. And so, you can't be a little ways in, he's still responsible at some level. They didn't have any problem holding him liable under the statute, where he met all the literal terms of the statute for liability, where, he owned the vehicle, didn't transfer title to his emancipated daughter's name, and allowed her to use his vehicle. They didn't have any problem saying, well, look, that's squarely with it. That's in the teeth of the statute, as they might say. That's in the teeth of the statute.
Yeah, I mean, the plain language of the statute says what the plain language of the statute says.
Right.
And just because I love to tease our episodes, the next episode, by the way, we're going to deal with a case on the Kentucky Motor Vehicle Act. We're going to talk a little bit about statute interpretation
Right.
and all the different ways. So for all the lawyers that want to hear about how to properly do this statutory interpretation, tune into the next episode. But for right now, we got to keep on moving. So let's move on to the next case. So, Lauren, how about this? Why don't you tell the audience what we're getting ready to cover next? It's still case law. We're still moving through it, but who do you want to throw it to next, Lauren?
Sure. Well, I'm going to throw this little curveball here. The next two cases, I think we should have Adam really dive into these.
Oh, I didn't have these assigned to him.
Well, surprise, Adam.
Well, it's just like law school, making sure I read the cases. I've read them. I'll be all right.
All right, stand up. You don't even know the cases yet. Which two do you want them to do?
All right. So the first case is Bryan versus Baer. It's a Court of Appeals case in 1977. The second case is Bearden versus Derry, another Court of Appeals case from 1983. And I noticed both of these cases mention this filing form SR-21. So, Adam, when you hit these next cases, can you go into a little bit more as to that, as I'm not really familiar with that?
And I'm sure most people aren't familiar with SR-21 form, and I wasn't until I read these cases.
I'd never heard of it until I read the case.
And really, unless you're in the insurance industry, I don't think you would be familiar with that form. But yes, I'll definitely talk about that. Let's talk about Bryan v. Baer first. And this is an interesting case because it brings in Section 1 of the statute and also brings in Section 3 of the statute. And in this case, you had a minor boy who was working with his neighbor, doing some work with his neighbor, digging ditches. And the neighbor let the minor use his truck to go get some shovels from his house. So you have the minor being furnished with a vehicle by Logan, is this defendant's name, and he gets in a wreck. Well, it turns out that the minor's dad had actually signed for his driver's license. So, of course, the plaintiffs sue the minor driver, and they sue the dad under Section 1, and then they sue Logan under Section 3 for furnishing the vehicle. And in this case, dad signed for the minor, but he also had insurance. So you would think under the statute, he's free and clear. And Logan was clearly on the hook. What happened was both defendants filed a motion for summary judgment asking the court to find that since they had insurance, the statute does not apply. And their argument was this SR-21 form. And you're sitting here thinking, what's an SR-21 form? Well, this is a form that the insurance companies would file stating that the minor has insurance. And the argument was made by the plaintiff that since the SR-21 form had not been filed before the wreck happened, they didn't comply with the statute, and therefore they're on the hook, both dad and truck owner. And the court says...
And when I read that, I thought it was really strange because I thought, I've been buying insurance since I was 16 years old, and I've never filed a form, SR-21. So...
Right.
And I don't even go look for them, although now I probably will.
Well, in reading these cases, it seems like the form really doesn't matter. And the court kind of says that. It's putting form before substance. It's here's a quote from the court. It says, "We do not believe that the major purpose of the statute is the filing of a form, but rather the acquisition and maintenance of a policy of insurance covering the minor at all times." So it gets to the root of the legislative purpose behind the statute is to make sure these minors who are driving, who are less experienced and probably more likely to cause a collision, are insured. And if you're not going to be insured, then you're going to be on the hook for them. And that kind of dovetails into the next case.
So, but that's a pretty clear one. I mean, the court just says, generally have insurance.
Right.
And that's going to be the takeaway on the Form SR. Lauren, you got that? You got the form now? You know what we're
I do.
Good. Adam, anything else on Bryan versus Baer that you want to cover, or that kind of covered?
That covers it. Basically, this is one of the first cases that I read that talks about the true purpose of the statute and says this form SR-21 really doesn't come into play.
Got it. And then, as Lauren said, Bearden versus Dairy. You ready to move there? That also talks a little bit about it, but gives some other points as well. So
Yeah, this case, Bearden versus Dairy, this is a 1983 Court of Appeals case, and in this case, you have divorced parents. Dad signs for the license for the minor, but the minor lives with the mom, and the mom gets the car and provides the car and has insurance, and mom has control of the car. And the minor gets in a wreck, and they sue mom because she furnished the vehicle, dad because he signed for the license, and the minor child. And under the facts of this case, the court said clearly the mom's on the hook. She had control of the vehicle. She furnished the vehicle. A little wrench in the spokes here. Dad was still the titled owner of the vehicle, but the reason the court let him off the hook for Section 3 is because the divorce papers were clear that the mom got the car in the doors. So dad's out.
the car really belonged to mom. The court said the divorce, it was supposed to already be put in her name.
Right.
Theoretically, the title had already changed just by the signing of it.
Right. Ownership had changed. They forgot to transfer the title over.
Hadn't gone down to the clerk's office yet.
Right. And then, so the next argument for dad's liability was he signed for the license. And they argued that, well, dad didn't provide the insurance, mom did. And this is where they talk about the SR-21 form again. And they say, the court tells us that's form over substance. There's insurance on the vehicle. Even though dad signed and he's not paying for the insurance, the purpose of the statute is to make sure that the child's insured. And that was the case in the situation. So dad was off the hook.
Good. All right. So it's kind of, the statute, when you look at the plain reading of it, is pretty clear. And it seems like that followed, hey, the intent is this. The intent is to have insurance. It's to provide coverage when it's supposed to be there. And they followed that, right?
Right.
Yeah. Good. All right. So the next case is one I've been waiting to get to because I just think it's kind of a neat case. And Kevin, I'm going to throw this one back to you because there's a lot of moving parts going on over here. The case is Wolford versus Wolford. It is a Supreme Court of Kentucky case from 1984. And literally when I wrote my notes and I sent it to Kevin, I said, my note is, this is a strange case.
Yeah, it's a strange case. It's like
But it's fun.
It seems like it's out of maybe my family history along the way. So here's what happened. We'll just
hold on, man. If you're listening to this in the car, pull over. You want to listen.
This is good stuff. This is a good yarn right here. So okay, here's the situation. Here, we'll just use first names here. The Wolfords, we know that's a family name because it's Wolford versus Wolford. Harold is the father. Harold owns and operates a trailer park, and he's got 5 vehicles.
And Harold was my grandfather's name.
Right? See, Harold. It's a good name.
So Harold's the dad.
Harold's the dad. Owns and operates trailer parks. Got 5 vehicles, and initially those vehicles are under a business policy because they're related to the operation and ownership of the trailer park. Harold also has a son. And age 16, Harold takes his son to get a license. He signs the license. Charles is the kid's name. He signs Charles's license, the application for a license. And then he does everything he's supposed to do. Harold does. He notifies his insurance company, Trinity Universal. Says, hey, I got a kid and just got licensed, and I want to switch one of those cars from the business policy to a personal policy. They do that, and so he makes that car available for his son to use. But
to make sure, Harold had 5 cars in his business, his
right.
trailer park business.
Right.
And he says, why don't you drive in one of the business cars?
Right.
We're going to switch it over on the insurance. We're going to have insurance, and just pulls one away and puts insurance on that.
That's correct.
Okay.
It's a 1978 Ford.
Okay.
So, but then, Charles, the kid, he's got some issues. Charles is, spirited, let's say. And
16-year-olds are spirited.
They seem to be. That's been my experience.
Definitely been my experience.
So they get into a big old fight, and Charles, leaves. So it's sort of the situation we were talking about earlier about emancipation, but they never use that word in this case. Charles leaves. He's like, I'm out of here, Dad. Forget you, your trailer park. I don't even care. And so he leaves. But then he comes back these things, it's a bad situation.
Right.
Comes back to his dad, says, hey, can I, use that Ford? And Dad,
I thought I was all grown up.
I thought I would hit the big time.
Sure could use
Turns
your
out
help.
I didn't. But I need that car so I can hit the big time, Dad.
Right.
So but Dad's like, oh, no.
Do you think he apologized?
No. I mean, do kids apologize? Is that a thing? That's not been my experience.
I'm
But
gonna act like he did.
yeah, okay. So he comes back and he says,
We'll call
Dad,
him polite Charles.
right, Charles. Charles is politely asked. But then Harold, he says, no. It's what I would say. No, I'm not giving you my car. You don't get my car. So
I guess he did not apologize.
Right, he did not apologize. So and Harold's a little bit. He's worried. His son is troubled. So he's like, I think he might be high too. I think he might be on some drugs. And so he's not gonna let Charles drive it. App says, nope, no way.
And look, parenting's hard. There's a lot of things
Oh,
we do.
so many things.
So many things.
Yeah.
But Harold, in this case, he's doing his best. He's trying.
Right.
The kid comes back. Charles comes back. We were joking about it. He wants the car.
Right.
And Charles tries to make the right decision, which is, look, I think you're high.
Yeah.
And I'm not going to give you the car. I'm not going to let you use it.
Right. Harold. Right.
Harold says,
Yeah.
tells his son. So he's kind of doing the right thing. Like, don't let your kid have the car high.
Harold, as a parent, is checking all the boxes.
He's checking all the boxes. But
yeah, he's doing the best he can.
See how it turns out.
Yeah. So what's Charles do? Anybody? What do you think, Rob? What do you think Charles did? Charles obviously.
Charles said, Dad, I understand. You make a good point. You checked into rehab.
The responsible thing to do would not be to take this car. That's what Charles.
You think that, Lauren?
What do you think, Lauren?
Probably not.
Right, because I wouldn't. Okay, so
Charles takes the car. To our listeners, Charles takes the car.
Long story short, Charles takes the car. Okay, so Dad finds out, Harold finds out. So Harold's like, "Oh no, that's on." So he gets in one of his other cars and chases his son. He goes after his son. Says, "I'm going to get this kid." So high-speed chase ensues. Father also alerts the authorities. So then there's I can't even imagine the scene.
I envision like helicopters.
Oh my gosh, it's like the OJ kind of thing going down, but faster. So he.
I was only 10 when this case came out, but I think I saw it on the news.
Yeah, exactly.
Or maybe that was a white Bronco.
It could have been. But I think this one sounds more exciting in a way. So
anyway, so they're now chasing this kid.
Dad chases a kid. Dad alerts the authorities. So now you've got the police involved. Police coming after this kid. High-speed chase. Somehow, it ends with Charles hitting the police officer. Okay, so he rams the police officer, and that's where the police officer is injured, and then sues both Charles and his father Harold under Section 1 of the statute. Okay, so he says, "Well, look, you signed his application. I understand. I hear your story about no permission and all that, but you signed the application, so you're liable." And then it gets even. So that's a weird set of facts, but then it gets a little weirder even under the legal analysis.
But how can it be under number 1? He had insurance on the car.
Right. See,
this is where this case really starts to.
That's where it where legally it goes off the rails. It went off the rails factually for poor old Harold already, but now so legally.
But for the listeners, Dad signed originally, and the car does have insurance, as we talked about.
Trinity Universal, it covered it.
Okay, good.
Right, but. The argument is under Section 1, okay, you signed, we know that. But the reason there's no insurance is because Harold didn't give permission. Harold didn't give permission to his son that there was no insurance, there was no coverage under the policy because so effectively the vehicle was uninsured at the time of the wreck. because Harold did not give permission to his son to drive. That was the
So
argument.
insurance company basically comes in and says, you didn't give him permission. That vehicle's not insured.
Right. And the insurance company doesn't even provide a defense to Harold. So Harold's on his own. He's, he has to defend this action without the help of his insurance company. And the plaintiff has used the fact that there's no insurance on the vehicle to get a Section 1 liability on Harold. Okay.
So make sure the listener understand. He signed the license. He bought insurance.
Right.
But the kid's high. He's like, you can't use the car. The kid takes it. Insurance company says, well, then the insurance policy that you bought isn't covered.
Correct.
So now he's in violation of Section 1 because he's letting the kid drive, although letting's a broad term, letting the kid drive a car that doesn't have insurance.
Right. And under Section 1, because it just depends on the signature and no insurance, regardless of permission, that's where that's the argument to hold Harold liable.
What does the court do? Let's keep this one there.
Yeah. So the court looks at it and says, okay, we understand there's no permission, but then it looks under a separate section of the policy, which says that which imposes coverage on behalf of Harold as the owner of the vehicle. So he's clearly the owner of the vehicle. So the company looks at Part 4A1 of the liability policy, and it says any accident resulting from the ownership, maintenance, or use of a covered auto. And the court looks at that and says, that's a separate section. That's independent of the permissive use issue. There's coverage here for Harold under this language. Okay. So, they say the policy language isn't limited to use authorized by the insured or anything like that. So it's not qualified. So they say, okay, you're on the hook under Section 1, but Harold, you're covered under this language of the separate language under the liability policy. So you do have insurance. Now, by the time it gets up to the Supreme Court, there's an $80,000 judgment hanging over Harold's head. So it goes up. He's got the judgment. Really, that's not an issue in this case, whether there's, going to be an $80,000 judgment in favor of the police officer plaintiff versus Harold.
Who's responsible and is there insurance coverage?
Right. So the Supreme Court goes through this analysis and says, okay, there's coverage. You're Trinity, you're on the hook for the $80,000 judgment. And because you didn't provide Harold a defense, you also have to pay his costs and attorney's fees and all that stuff because he was out on his own.
Because they chose not to defend.
They elected not to even provide him a defense. So that's how it happened. That's how it went down.
Yeah, it's interesting to make sure the listeners understand then. So he signs the license and gets insurance. Kid steals the car, so the insurance coverage doesn't cover it. Now all of a sudden he's driving a car that doesn't have insurance, and Harold's responsible under Section 1. But Harold's insurance policy, so now Harold is responsible.
Harold.
And insurance policy now that had said we're not on the hook because he stole the vehicle is on the hook because it is now imputed negligence, imputed liability to Harold, and they do have to cover Harold's liability. So they come back on the hook.
They come back on the hook on the back end and cover Harold, and then make the insurance company pay the full $80,000 plus the attorney's fees and costs that Harold might have incurred in defending the
because
lawsuit.
Now you have an insurance company that chose not to defend because they thought they were off the hook. And in this case, the insurance company should have read, or, we should have made this podcast 30 years ago.
Then they would have known.
Then they would have known 196,590 means you have to pay.
That's right.
It's a great case. It's a very, very interesting case, but it kind of shows you how these things can play out and how a big takeaway is it is imputed liability. It does make whoever the parent or whoever loaned the car, the adult, liable.
Mm-hmm.
And then your insurance company, while they may or may not cover the person driving, does step in and cover you.
Right.
So you have that protection, which was what the statute wanted to do, which is to have this greater protection.
That's exactly right.
All right. Well, that's great. Well, I tell you what we're going to do. I think we've gone through a lot of the cases in detail, and I hope our listeners have a really good understanding kind of how the statute worked and the cases. There are a number of other cases, 6, 7 cases, I'd like to transition into the last transition of the section of the podcast. It'll be very short, where we're just going to kind of fire real quickly in 30-second summaries, summarizing kind of these last 6 or 7 cases that repeat a lot of what we've said, but just so you have a complete understanding. All right, here we go. Welcome to section 3. We're going to call this the speed round. We're going to take these last 6, 7, 8 cases and give little 30-second summaries of them. So here we go. Number 1, I'll go first. Peters versus Fry. It's a Court of Appeals opinion from 1968. Interesting little case. In this case, an employer, trucking and excavating company, they gave a minor a vehicle to use. So they gave a minor a vehicle to use, and obviously the company could be on the hook, respondeat superior, et cetera, because it was in the business. But the real question was, the supervisor that gave him the car, could he be held liable for giving him the car? And the court said, yeah, look, it's a company car. You're the supervisor, gave it to your employee, although he was a minor, and let him drive it. So you are liable for letting him use the car under 186-590 Section 3. So that is the Peters case. Kevin, I'm going to throw it over to you. What's the next one?
Benton versus Parks. Do I get an award if I can do it really quickly?
Yeah, well, but you're behind the boat.
Oh,
I'm pretty competitive, Kevin, too.
Oh my God. But Benton versus Parks. No. So this one involves a minor driving a vehicle that was owned by the minor's brother. And long story short, minor gets involved in the wreck. Brother says, well, I'm not responsible because I've got insurance. And the court rejects that argument. They say, look, that's a different issue. That Section 1 and 2 is different from Section 3. We're imposing liability on you, brother, under Section 3 because you allowed the minor to use the vehicle.
Yeah, when I was reading these cases, I was waiting for someone to make the argument as I was reading them in order. Hey, Section 2 that says if you have insurance, you're not responsible also applies to Section 3.
Right.
It's made in 1954, and the court rejected it. It's clearly not applicable to Section 3.
That one's done.
But if you wanted a case, we now have it.
Right.
Kevin, you were not ahead on the time so far. But let's see how Adam does. Adam, what's your next one?
Asher versus Russell, Court of Appeals, 1964. This is a 2-vehicle collision. This case mainly focuses on whether or not there's enough evidence to get past directed verdict. But at the end of the case, it talks about how an adult gave a 17-year-old permission to drive his vehicle. 17-year-old caused the wreck. So under Section 3, the adult friend was on the hook.
17-year-old had permission. They're responsible.
Correct.
All right, moving along. Lauren, let's have Lauren do one. Lauren, go ahead. What case do you have?
All right, so I have Lawhorn versus Holloway, a Court of Appeals opinion from 1961. Mr. Holloway's 17-year-old daughter caused a wreck. Under KRS 189.590, the minor's negligence was imputed to her dad. A side note here, they were coming from Coney Island in Cincinnati. I've never been to Coney Island.
Oh, my gosh, I love
Sunshine Pool.
Yeah.
That's they shut Coney Island down.
They did.
Oh, they did?
Yeah, but they're using it for like a concert venue.
They're redoing River Bend.
Yeah, it's a sad note. But I wanted to talk about that just because it's Coney Island. But as far as the summary time, I think Lauren is winning. That was a pretty quick summary and pretty easy.
Good job, Lauren.
All right, well, we'll see who gets the award.
Very disappointed in myself.
We have 2 more cases, so let's rock through that. All right. The next one I'll take, Fallender versus Hankins. It's a Court of Appeals case from 1944, so we're going really far back. An employer, the name of the employer was Phoenix Garage, had a 17-year-old that put a new thermostat in a customer's car. So the customer brought their car in, needed a thermostat. The 17-year-old did that, and the boss said, hey, can you return the car? I guess they did that back in 1944, over to the owner. Can you take it back to her house? Well, he decides to go on a joyride on the way. He's in a wreck, and the question is, who can be responsible? They did say, look, he's not working. He was out on a joyride, right? So it wasn't the business's fault. But his boss let him use the customer's car to return it. So while he may not have been working, boss gave permission to use customer's car. So boss was on the hook under 186, 590, Section 3. And it's a real interesting case because in this case, boss was giving permission to drive someone else's car. It wasn't even his car. He gave permission, but he had the right to get permission because it was in his custody and control. So when you're evaluating your cases, it's not necessarily who owns it, right? If you have it for another reason, you can also give that permission. And they held him liable under 186, 590. I'm not getting the award because that was too long. Kevin, we got the last the award for the fastest summary. Kevin, we've got one more to go. Go ahead. Finish this up.
Cook versus Hall, case from 1948. This one, the father had a delivery truck. Son took the delivery truck for a joyride, caused an accident. There was evidence in this case that the son had permission on previous occasions to use the delivery truck, but there was evidence that the father did not give permission for the kid to use the truck on this occasion or to drive the truck at night, apparently. So the issue was, well, and also there was evidence he took the keys to the truck without the father's permission. So the question was whether dad could be held liable under Section 3 of the statute. Court said he wasn't because there was not permission. I do wonder, this is a circumstance where maybe permissive use has developed in the law since 1948, and under a more recent case called Mitchell versus Allstate, whether a broader definition of permission might apply under these older cases. So I don't know that the result would be the same, is the point here.
The analysis would be the same. Do they have permission?
Would be different.
Kentucky law has developed what actually is permission and how broad that is. So for listeners' takeaway, whenever you have one of these minors cases, you're looking for any evidence of permission. And of course, you'll always apply the ongoing analysis under Kentucky's permissive user rule.
And long story short, Mitchell versus Allstate is probably for another podcast. But I will say that the court generally finds permission unless you're deemed a converter. Basically, if you stole the vehicle, then you did not have permission. If you did not steal the vehicle, you're more likely than not, the court's going to find permission.
It's probably permission.
Right.
And that certainly is developed in Kentucky law.
Correct.
Good. Maybe we'll do a whole different podcast on that.
We could.
Yeah. All right. Well, that wraps up Section 3 of the podcast, which in essence wraps up the entire podcast. Again, if you were one of the non-lawyers tuning in to find out the answer to this question, we are glad to have you here. Would love to have you follow the podcast. We do cover lots of legal issues, which I think you'd find interesting. To all the lawyers that are always emailing us and following, we really appreciate you listening. Kevin, thanks for being here again.
Oh, it's so much fun.
Adam, glad you got to join us. I hope you come back.
I'd love to.
Good. And then, of course, Lauren is here every time, kind of guiding us all through it. She takes care of us. I will remind everybody that if you email me, Robert Mattingly Attorney @gmail.com, or if you email Kevin at burkeneal.com. We have a computer file. We'll just email you the entire case file, so you will have all these statutes, you'll have all these cases, and you can kind of start saving research files on the issue. And also remember, because of the Auto Summit, we are giving out this podcast and the next several as free CLEs.
Hold on a minute. Did you say free?
I did say free CLEs.
Oh, my goodness.
Yes. So here in just a second, when the approval number comes back, producer Jim will add it at the very end of the CLE. So everybody, we'll see you next time. The way that we always sign off, I'm going to test Adam here. We sign off the same way. Let's see if he's listened to other podcasts. Adam, how do we sign off every podcast?
Until next time, we want to challenge you. Go find one thing you can do to change the world.
All right. See you next time.
Friends, this is podcast producer Jim Ray. And as Rob mentioned, we are offering free CLE credit for this episode. So we are still waiting on the activity number. If you are an attorney and you would like free CLE credit for having listened to this episode, go ahead and just email Robert Mattingly. His email address is robertmattinglyattorney@gmail.com. Once we have the activity number assigned, we'll be sure to send that right over to you. As always, thanks for listening to this episode of the Legal Notepad Podcast.